You brought a lawsuit against your doctor claiming that he was careless and caused you significant harm and injury. And during the course of your lawsuit, the defense finally makes an offer to settle your case that is now agreeable to you. What documents are you going to have to sign in order to finalize your particular settlement? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Well, congratulations. The defense has now made you an offer that you and your attorney agree upon. That's terrific. But now, before you can actually get that settlement money, you have to sign certain documents that basically says, hey, listen, I agree to drop this lawsuit. I agree to the following other terms and conditions in order to get the money that you have offered to me. So now, in a medical malpractice case in New York, let me share with you exactly what documents you're going to have to sign. The first thing you're going to have to sign is something called a general release. The second thing you'll have to sign is something called a hold harmless agreement. The third thing that has to be provided to the defense is a stipulation of discontinuance. So let me tell you what these things are. The first thing is a general release. What is that? That's a piece of paper that you sign that basically says, I understand that I sued this doctor and his professional corporation, but in exchange for him giving me $1 million, or whatever other amount it is that you agree to, I now agree to give up all of my rights to continue this lawsuit. I agree that I can never come back and sue this doctor again for the same problems, the same complaint that I brought this lawsuit for. I am agreeing forever and always to give up that right. That is called a general release. The defense will not settle your case until and unless you sign that document. Okay, what's the next one? The next one is something called a hold harmless agreement. Now, there are instances where somebody turns around and says, hey, you still owe us money because of medical care and treatment that you received because of this careless doctor. Interesting. And now they go ahead and do what? Now they go ahead and go after the defense or go after the insurance company who's now paying. And you say, no, no, no. We agree to hold you harmless for any amounts of money that are still owed, and we will go ahead and be responsible for that. So that's the second document. It's called a hold harmless agreement. The third thing is a stipulation of discontinuance. That's a document signed by the attorneys that tells the court, okay, everybody in court, we want you to know this case is now settled. The parties have agreed to settle this case. Here is a formal document agreeing to discontinue this action. Those three things are typically what's required in order for you to get your settlement check. And there are specific ways in which those documents must be prepared, as well as signed, as well as delivered to the defense. Those settlement documents now have to be submitted to the defense lawyer and his law firm by a very particular way. We have to send it to him by certified mail, return receipt requested, if we expect to get that check within 21 days. Otherwise, if we send it by regular mail, they can take their sweet time because there's no requirement on how long that check should take to get to us if we deliver those documents by regular mail. So now if we want to get paid within 21 days, the way to do it, we deliver those closing documents to the defense by certified mail, return receipt requested. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and if you have not yet started a lawsuit, but are now thinking about doing so and have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.